call this hearing to order of the Senate Committee on Agriculture, Nutrition, and Forestry. So pleased to see all of our colleagues here for this really important hearing and discussion. We're here today because a rapidly increasing number of Americans are investing in cryptocurrencies. Yet there's no federal oversight over the tokens that make up the majority of this market. And just as quickly as these assets have risen in popularity, we have seen their value drop. As a result, hardworking Americans have lost billions of dollars they used to support their families, keep roofs over their head, and nestle away for hard-earned retirement. In the past few months alone, numerous companies have gone bankrupt, and the value of some widely traded coins has dwindled to cents on the dollar. Meanwhile, $1.9 billion worth of cryptocurrency was stolen in hacks in the first 7 months of this year alone, up 60% from this time last year. At the same time, it's important to recognize that cryptocurrencies and blockchain technology offer an alternative to using large financial institutions. 1/3 of Americans who have bought or traded crypto earn less than $60,000 a year. Some of whom lack trust in these institutions or find them too costly. They simply cannot afford, though, to lose their savings because of a lack of guardrails in these markets. And that's where we come in our responsibility as overseeing federal regulators. We need to have clear, consistent rules of the road that allow good actors to innovate and grow while first and foremost keeping customers safe. As the committee with oversight over one of our nation's 2 market regulators, it's our job to ensure that we bring the necessary protections to this marketplace. Together with my partner, Senator Boozman, and with colleagues, Senator Booker, Thune, Ernst, and Gillibrand, we have introduced the Digital Commodities Customer Protection Act. This bill gives the Commodity Futures Trading Commission oversight over digital assets that act like commodities, such as Bitcoin and Ether, that currently have no federal oversight. This is a glaring hole in our financial system, and I believe we must close it. Our bipartisan bill will require that all digital commodity platforms register with the Cftc. This will set a uniform national standard and allow the Cftc to catch fraud before it happens. As its name suggests, our bill is focused on consumer protection. It will require that platforms segregate and safeguard customer assets, hold sufficient capital, and abide by rigorous cybersecurity standards. It will eliminate many of the conflicts of interest in this market. And it will mandate that platforms speak truthfully about the risks of trading digital commodities and don't engage in misleading advertising. The CFTC is the right regulator for the job. Congress gave the agency oversight over the swaps market in Dodd-Frank, and it responded by setting the global standard. Our nation's derivatives markets have been a mainstay for our producers during recent supply chain disruptions and elevated commodity prices. We'll hear today from Chairman Benham shortly about how the CFTC has been a leader in policing the crypto markets for fraud and abuse. And this week we received a letter from former Republican CFTC Chairman Christopher Giancarlo expressing his support for the bipartisan bill. And without objection, I would enter this into the record. So ordered. This bill also gives the agency additional resources to get this job done right, which is so important. Finally, it recognizes that other financial agencies have critical roles to play in regulating digital assets, also important. I'm pleased to see Chairman Gensler's recent comments about how the CFTC and SEC can work together to make this market work, just as we did in putting together Dodd-Frank. And we've had productive discussions with SAC staff about the bill, which we appreciate and will continue. As President Biden has recognized, this is a big responsibility with a lot at stake, and it's going to take all of us at the table working together. At our table today will be some of the brightest leaders in this space, and I look forward to hearing from each of you on how we can continue to bring transparency and accountability to this marketplace while still enabling the innovation that makes this technology so promising. I'd like to turn now to my colleague and partner, Senator Bozeman, for his opening remarks.
Well, thank you so much, Madam Chair, and it's great to be with you today as we examine S4760, the Digital Commodities Consumer Protection Act. This bill, which I'm proud to co-sponsor with the chairwoman as well as Senators Thune and Booker, will bring much-needed regulatory certainty to the growing digital commodity ecosystem. As this industry continues to grow, questions remain about the proper role federal regulators will play. I believe regulation must ensure market integrity and consumer protection while also fostering an environment that encourages innovation. I believe our bill gives the CFTC the authority to do just those things. Currently, the digital asset spot or cash markets are subject to a patchwork of regulations at the state and the federal level. This is simply inadequate from market structure and consumer protection perspectives. It's without question that digital commodities and related technologies will continue to play an important role in the global economy for decades to come. As a result, now is the time to provide regulatory certainty to the market and create a framework that makes sense from both a domestic and an international perspective. It's imperative that both Congress and regulators work with industry and consumer advocates to ensure the laws and regulations for market participants are created through a transparent process that results in a clearly understood set of rules. Anything less hurts everyone. Regulation by enforcement without any meaningful engagement with market participants is no way to police the industry. It's unfair to stakeholders who operate in good faith, but are then punished because they haven't been given clear rules of the road. Ultimately, this committee's goal is to establish a framework that allows industry to innovate and grow while providing the CFTC the resources necessary to write and enforce rules that protect consumers and provide retail participants the ability to fully understand the functions of the commodities they are buying and selling. I hope today's hearings provides an opportunity for both Chairman Benham and our esteemed panel of stakeholders to weigh in on the most important features of our bill, including constructive recommendations to improve the bill as we look forward toward a committee markup in the near future. In closing, I'm confident the CFTC can rise to the challenge to be the right fit for an expanded regulatory role in the digital commodity spot market, and I'm confident that we can work together to protect consumers and allow this ever-growing technology to flourish. I want to thank Chairwoman Stabenow for her leadership and look forward to today's discussion and hearing from our witnesses. Before I conclude, I would like to welcome one staffer to the committee and then thank another staffer who will be leaving shortly. First, I would like to welcome Erica Shabbat. Erica is the new Majority Staff Director for Chairwoman Stabenow, but is certainly no stranger to the Senate. For the last 20 years, she served as Senator Leahy, a member and former chairman of this subcommittee, or this committee, which who we all know and are going to miss as he retires. But we really look forward to Erica and look forward to her service to the committee. Secondly, I would like to thank Darren Gurries of my staff for his exceptional service to the Senate and committee. Darren is a native Kansan and has spent the last 15 years working for the Senate. For the last 7, he's worked for the Agricultural Committee, first for Senator Roberts and now for me. The legislation that we're discussing today is largely the product of bipartisan negotiations led by Darren and Lucy, working hand in hand to, I think, produce a very, very good product. The committee and the Senate have greatly benefited from Darren's expertise, judgment, and charm. We will miss Darren as he leaves the Senate. I wish him great success and many thanks for his service. And we're trying not to be bitter over the people that have hired him, but it's okay. Thank you, Madam Chair.
Well, thank you, Senator Bozeman, and thank you so much for recognizing Erica. We're so pleased to have her here. Welcome, welcome. And Darren may think he's leaving, but actually, I think we're not going to let him. Right in the middle of all this, really. Oh my goodness. So, but I do so appreciate our wonderful staffs. We have been so fortunate on the committee. Past, present, with some of the smartest, hardworking people that there are, and we very much work in partnership, and certainly on this bill that has been hand in glove, and we really appreciate all of that. So, well, let me turn now to our first witness. Russ Benamy is chairman of the Commodities Future Trading Commission, and certainly no stranger to this committee either. Prior to his time leading the commission, Chairman Benamy has served as a commissioner. He served since 2017 on the commission, and prior to that was a valuable member of our staff on the Agriculture Committee. So welcome, Chairman Benamy, and we recognize you for 5 minutes of testimony.
Thank you. Chairwoman Stabenow, Ranking Member Bozeman, and members of the committee, appreciate the opportunity to be here before you today to discuss the Digital Commodities Consumer Protection Act. Last February, when I testified before this committee, I noted that the unique characteristics of the growing digital asset industry necessitated a comprehensive federal regulatory regime. I believe that to be more true today, and thank the committee for taking steps to address these needs through the DCCPA. I have directed staff at the CFTC to analyze what additional needs we would have to support its implementation. Digital asset commodity cash markets have significant speculative retail participation, often use high levels of leverage, and largely rely on platform-based custody arrangements outside of the traditional regulated banking sector. Market participants may perceive themselves to be interacting with exchanges and intermediaries regulated like those in other traditional financial markets, but the reality is quite different. Since I last testified, over $1 trillion in market value has been lost in conjunction with the failure of several large, high-profile firms operating in the shadows. One lesson is that leverage, interconnected markets, and contagion can wreak the same havoc in the digital asset ecosystem that they do in our traditional financial markets. As I have publicly stated several times, including to this committee, many digital assets constitute commodities. As recognized by the DCCPA, the CFTC's expertise and experience make it the right regulator for the digital asset commodity market. The CFTC facilitates customer protections through its principles-based market oversight and disclosure regime aimed at ensuring transparency, integrity, and security of transactions. These structures inform customers about who they are dealing with and provide clarity on the risks of participating in our markets. In requiring digital commodity brokers, dealers, and custodians to join a registered futures association, the DCCPA acknowledges the key role that self-regulatory organizations, like the National Futures Association, play in safeguarding the integrity of markets. The CFTC has often adapted its oversight capabilities to meet the demands of evolving markets. Most notably, in the wake of 2008 financial crisis, Congress provided the CFTC authority over approximately 95% of the swaps market, serving as the cornerstone of a robust regulatory regime for the $350 trillion swaps market. Returning to the digital asset market, since 2014, the CFTC has brought almost 60 enforcement cases, including a recent matter involving a $1.7 billion fraudulent Bitcoin scheme. With a lack of full visibility into the digital commodity asset market, the agency's enforcement program has had to lean primarily on tips and complaints from the public to identify fraud and manipulation. The agency has developed a deep understanding of this novel market and the underlying innovations that fuel it, hiring specialists, forming internal task forces and working groups, leveraging public-private partnerships, and most recently restructuring the CFTC's Financial Technology Hub into the Office of Technology Innovation. The DCCPA leverages the historical strength of the CFTC as a market regulator by requiring registration and supervision of digital commodity platforms and digital commodity intermediaries, as is required in CFTC-regulated derivatives markets. Digital commodity facilities will be subject to compliance with core principles, prescribing, among other things, that the platforms establish and enforce rules minimizing conflicts of interest, prohibiting abusive trade practices, establishing system safeguards to minimize cybersecurity and other operational risks, ensuring the financial integrity of transactions and intermediaries, and protecting customer funds. Critically, all digital commodity platforms must maintain adequate financial, operational, and managerial resources, segregate customer funds, and comply with commission requirements for the treatment of customer assets. These tools have proven effective in preserving customer funds and market operations in times of instability, uncertainty, or market misconduct. The DCCPA directly addresses the increased role of retail participants in the digital commodity asset markets by directing the Commission to adopt customer protection rules requiring digital commodity platforms to disclose to customers material conflicts of interest and material risks of trading digital commodities, establishing duties to communicate in a fair and balanced manner, and establishing standards for the platform's marketing and advertising. With the additional resources contemplated by the funding mechanism in the bill and a clear mandate for customer education and outreach to ensure that our efforts reach all demographics, the CFTC can swiftly effectuate this new regime. On September 21st, 1922, nearly 100 years ago to the day, the Grain Futures Act of 1922 was signed into law, which led to the near immediate establishment of the then CFTC. With that legislative accomplishment, this committee and the Congress swiftly responded to a policy need that arose on the heels of emerging risks to American consumers because of then new financial markets and products, technological innovation, and the promise of economic development. With the CFTC's rich history overseeing commodity markets, coupled with its expertise and track record, which rests on a firm foundation as a forceful and disciplined cop on the beat, the agency stands ready to tackle these new risks and opportunities 1 century later. Thank you, and I look forward to answering your questions.
Thank you very much, Mr. Chairman. As you've indicated, and I've spoken about as well, cryptocurrencies are traded largely by everyday Americans right now. And some people have voiced concern that the CFTC does not have a customer protection mandate and therefore may not have the tools that you need to protect these retail customers. Could you respond to that?
Thank you, Senator. Before I get into any details, I would say unequivocally the Commodity Exchange Act and the rules that the Commission promulgates from the law directly support customer protections, full stop and without question. And thinking about the layers, because I think there are several layers to the customer protection regime at the CFTC, I think it's important to identify each. At the sort of foundational level is the law itself and the rules that we implement, which are more prescriptive and have more specific requirements for the registered entities, which you do in your bill. The core principles can be anything from system safeguards, which directly address cybersecurity and operational risks, and this is directly about protecting customer funds and customer assets. Conflicts of interest, something you noted, which is a big concern in this issue area. A core principle. We would have to ensure registered entities, which your bill contemplates, whether it's the trading platforms, the brokers, the dealers, the custodians, are serving the best interest of the client or the customer only, and no one else. We have core principles about reporting and record keeping. This is information flow that comes to the agency so that we can monitor, for example, disruptive trading practices and making sure that the market is free from fraud and manipulation. Also, prohibiting contracts being listed on trading platforms that are readily susceptible to manipulation. These are just a few of the nearly 24 core principles which make up the regime and ultimately are manifested through the rules we prescribe. I would say the second layer is how do we make sure that our regulated entities are complying with these rules and regulations? We do this through a series of inspections, examinations, and investigations. We work in tandem with our partner, the National Futures Association, which again is another provision you include in the Act to create a self-regulatory regime to ensure that the individuals and institutions that are regulated by our market are complying with the law. And we make sure that they have the adequate proficiency and information they need to comply with the law. The third thing I'll mention is enforcement. We have to ensure that individuals are held accountable for breaking the law. This is obviously one of the key components of our requirements as a civil litigator. Within our agency, and Chairwoman, you know this, we've struggled with funding over the past decade or so, and I've looked at some data points. In the past 10 fiscal years, our average budget has just been over $240 million per year. In that same period, this 10-year period, the Division of Enforcement has assessed penalties on average of over $1.5 billion per year. So a 6 times plus return on investment for the American taxpayer in enforcement penalties. A few months ago, I had the privilege of standing next to the Attorney General as he announced settlement with one of the largest commodity trading advisors that had manipulated oil markets. This was a civil and criminal case brought by Justice and the Cftc, over $1 billion. And in this time, we need to ensure our energy markets are free of fraud and manipulation. That case was brought by the Cftc. LIBOR, a benchmark, a financial benchmark which underpins trillions of dollars of financial contracts, student loans, mortgages, over 10 years ago was found to be fraudulent. The setting standard for setting the benchmark itself, which is in these trillions of dollars of financial contracts, was manipulated. Billions of dollars of fines assessed against financial institutions across the globe. That case was uncovered just downtown at the CFTC. So these are some examples of the work we do, from the rule set and the implementation, the law, how we enforce it, and the accountability. And I think layered on top of that, which are all things you include in the bill, which is extremely important, is the bankruptcy protection, which is another amendment to your bill to the bankruptcy code, and it's extremely important. We prioritize customer funds and customer assets above all else, above creditors and above security holders. So this, in total, I think is a very robust, very comprehensive customer protection regime, has worked in our derivatives markets very well for decades, and I think as you contemplate in your bill, will work as well in the digital commodity market.
Let me just ask one other question. Thank you so much. The President's talked about a whole of government response to the regulation of digital assets and this new innovation. Take just a moment about how you would move forward in working. Obviously, two very important agencies, CFTC, SEC. Again, we did it in Dodd-Frank. We've got two great regulators. Just speak about, as you move forward in this space, how you'll craft your regulations and how you see working together.
Chairwoman, it's not going to be any different than what we've done before, and you alluded to it, whether it was 2010 with Dodd-Frank or even going back 40 years with security futures and commodity futures. We are constantly talking at the highest level, the chair, enforcement, the different divisions. We naturally have intersections between our markets. We have duly registered entities, whether it's the intermediaries, the broker-dealers, and the FCMs, or the investment managers. We have to work together to make this work, because otherwise the markets wouldn't work like they should and like they're intended. So we have a long history of this. I don't think we need to try to fix something that's working right now. And I think it's all about communication, transparency, and understanding at a high level what the goal is, right? This is not about us at the CFTC. It's not about the SEC. It's about the regulatory framework. It's about financial markets. It's about protecting customers. And if we keep that goal in mind, I think we'll be able to accomplish what we're tasked with.
Thank you very much. Senator Boozman.
Thank you, Madam Chair, and I appreciate your question concerning enforcement. That's one of the things that comes up in regard to the bill. Does the CFTC have the ability, are they a strong enough enforcer? And I think you answered that question very, very well, explaining your role and the great job that you're doing with the resources that you have and punching so far above your weight. And yet, while still protecting the customer, while still enabling innovation. So again, thank you for, a great response in that regard. Another thing that comes up is user fees on derivatives market activities. And I had the opportunity, I've been on the subcommittee on appropriations that has to do with that, and really champion efforts to make clear that the CFTC does not have the authority to impose user fees on derivative market activities. That said, our current bill authorizes the CFTC to impose a user fee only on digital commodity platforms. Do you agree that our bill, as written, prevents any application of a user fee onto derivative market activity?
Senator, in short, the answer is yes. The bill is drafted prescriptively to ensure that the fee would only be assessed on the digital commodity platforms and not on traditional derivatives market entities.
Right. So it would take congressional authorization to do that.
Correct.
In fact, further, do you believe it is clear that the only user fee precedent, as a result of this bill, is to say that it would take additional legislation to authorize user fee in the traditional derivative market the CFTC oversees?
Yes.
Very good. I also want to thank you and your staff. They've done a very, very good job in providing technical assistance, not only with this bill, but again, just through the many years that we worked with them. One of the suggestions we've heard from numerous industry stakeholders is about the definition of dealer. Because our bill is intended to protect retail consumers, it's not our intent to cover proprietary trading firms who invest only for their own accounts to be covered under the definition of dealer. As currently written, do you believe our legislation covers this kind of non-retail consumer-facing market activity?
Senator, good question, and I think I agree with you in principle that we're trying to focus on retail customers. And in this case, yes, the principal trading firms, or the prop traders, as they're more commonly known, would be exempt from the dealer definition, and that's consistent with what the Act and this committee and the Commission have done with respect to traditional swap dealers. So that's my interpretation, and I think it's drafted appropriately to create that carve-out for proprietary traders.
Very good. Well, I think I'm going to yield back my time in the interest of getting all of the questions. We appreciate your answers. As an old staffer, you understand the importance of actually answering questions. So again, thank you very much.
Thank you, Senator.
Well, thank you very much, Senator Bozeman. Since I went over a few moments, I think we're now back to even. So thank you very much for that. I will now turn to Senator Klobuchar, and then I believe Senator Ernst will be here shortly, and she would be next. Senator Klobuchar.
Thank you very much, Chairwoman, and thank you as well, Senator Bozeman. Chairman, I think we've talked about this before. I appreciated you visiting my office as well. As you mentioned in your testimony, these are volatile markets. I think we all saw that big time when we saw that when digital currencies were approaching their highest values and the companies were spending all the millions on the, maybe even more, on the celebrity endorsements. I think we all saw the Super Bowl ads. Many first-time buyers were convinced to invest just in time for the market to crash. And there are people that are trading on these unregulated platforms that they may not even realize it. Many of the investors haven't even traded on platforms like this before. Could you talk a little bit more about how these underlying markets work and why you think the CFTC is in a position to oversee such a volatile market? I know you've done such things before. And without regulation, what recourse do consumers have who have been scammed or defrauded by crypto brokers? Kind of two different questions.
Thanks, Senator. I think in response to your first question, in many respects, the markets and the way that the unregulated digital asset platforms are set up and operate are very similar to the way our traditional markets operate. But as you point out, they're unregulated. The regulation is limited to FinCEN at Treasury and some state money transmitter licenses. But we don't have that market regulatory structure which provides that transparency and that lens into how the markets are operating. So notwithstanding some obvious custody issues, because this technology is so unique in how you custody the actual underlying token, the market structure is largely the same. And I think as we contemplate this bill, it's about shedding light on this marketplace that is otherwise in the dark. And we would apply the same principles that we have for decades that have worked quite well. And you talk about volatility, and I think that is in part, we're seeing correlations between the digital asset market and traditional equities markets and bond markets. But I also think that with regulation, we'll probably see reduced volatility because you'll have more participants and sort of tighter spreads between individuals willing to buy and sell these digital assets. So I think it's implementing our core principles, implementing the rules that we found to be very successful and effective, focusing on customer protections, focusing on protecting customer money, but implementing these core principles that are around trading practices, disruptive trading practices, ensuring financial resources so that the platforms can do what they're intended to do.
All right. A June FTC report indicated that since 2021, 575 million of the crypto fraud losses reported to the FTC were about bogus investment opportunities. I referred to some of this in my last questions. But many of these originated on social media platforms like Instagram and Facebook. Could you talk about the interaction with their platforms, what their role is, and what more could be done on that front? I really don't know what your answer is going to be on this. I just noticed this numbers in my briefings.
Yep, Senator, it's a very difficult area because we don't have a lens into the trading platform. So we're relying on customers, as I stated in my statement. Every case that we brought, 60 enforcement cases, has been brought to us through complaints. We don't have that vision and that lens into the trading platform. So
you're saying the bill would help to give you the transparency into it?
It would provide the authority to the CFTC to regulate markets. And this volatility, the fraud, the manipulation, much of it would probably go away because we now have a regulator, a cop on the beat, and this would deter activity by bad actors. So,
okay. There's a lot of bad actor activity going on social media platforms, as you know. This isn't the only thing. But a cop on the beat would be unique compared to a lot of the things going on. When considering the environmental impacts of the significant energy that's required to mine cryptocurrencies like Bitcoin, there's a lot of questions regarding the sustainability of cryptocurrencies. Can you speak to the way that this bill approaches the environmental impacts of cryptocurrencies?
Thank you, Senator. The bill provides and requires the CFTC to draft a report within 6 months and report back to this committee and the House Ag Committee in consultation with other U.S. regulators, most notably those that have expertise in the energy space. And I think this is the appropriate approach to this issue. We've all heard the statistics about the amazing amount of energy used to mine coins. I would say that an event occurred last night with Ethereum, which is going to reduce energy consumption, a step in the right direction, but certainly not resolving the problem. And I think at its core, the report will stand as a basic starting point so that we can examine what the issues are, where the energy usage is occurring, and what's the correlation between the energy usage and the outcome, the mining of the tokens. And from there, I think that would lead to future policy discussions, potentially disclosures, and hopefully incentives to move away from carbon-intensive energy sources.
Well, thank you very much. I have a lot of faith in you, Mr. Chairman, and look forward to working with Senator Stabenow and Bozeman and others on this. I did want to point out before we turn it back that we have with us the winning pitcher of the congressional softball game, Senator Gillibrand, who got 4 strikeouts. Joni knows she used to play in this team, and against all odds, beat the press that we'll just say was significantly younger, as we had 2 grandmothers on our team. And the congressional team beat the press, and we should be very pleased with Senator Gillibrand's performance as a pitcher. She was incredible.
All right, way to go. That's terrific. Thank you. All right, Senator Ernst.
Oh, wonderful. Thank you very much, Chairwoman Stabenow and Ranking Member Bozeman. Today's hearing, it is extremely interesting. I think we've probably got a lot of viewers out there that are interested as well. Chairman, thank you for being here. We have heard all of these concerns that cryptocurrency companies are being pushed out of the U.S. to other jurisdictions due to the lack of regulatory clarity. So I'd like you to walk through a little bit more how the bill would address those concerns and encourage American competitiveness, but then why also should we want to promote the U.S. as a leader and an attractive jurisdiction for cryptocurrency companies? What benefit does this bring to every American, even those that aren't engaged in cryptocurrency?
Thanks, Senator. Yeah, for sure. I've heard probably many of the anecdotes you've heard about companies needing to move overseas because of the regulatory uncertainty. I think this bill, in many respects, is one element of the larger digital asset crypto ecosystem, but it's certainly a huge step forward given the size of the market that you contemplate regulating. And I think with that regulatory certainty, the innovators, the entrepreneurs are going to have more incentives to consider staying within the U.S., raising capital here, and starting their businesses here. So it's the regulatory certainty, it's the understanding that the law will be clear, and they know how it will impact and intersect with their business and not fear something or unknown in the future. To your second point, I view this in many respects like any technological disruption or innovation that's occurred for decades. I mentioned the Grain Futures Act from 100 years ago in my opening statement. It was a different time when our farmers and ranchers were creating futures markets, and that was technological innovation at the time. And here we are 100 years later with a very different technological innovation. But I think it's important at a minimum, despite where the technology may go, and I cannot predict the success or failure of it, but there certainly is demand, there's certainly optimism, and I think there's a vision for it to be implemented into our economy. And when you have those core fundamentals being discussed and being outlined, then I think it's important collectively as elected officials and as regulators, we do what we can to balance customer protections against innovation and supporting the technology.
And if you could describe for us, what would happen if we don't move on this in the next 6 months, if we don't move in the next year? What's the potential there?
So it's always difficult to give an exact timeline to when things may shift within the marketplace. I think, quite frankly, the U.S. does a very good job, and I'll speak only from a financial regulatory position, of balancing the need to move cautiously to ensure that we're embedding the principles that have worked well for our capital markets and our derivatives markets for over 100 years. And that means moving slowly, thoughtfully, but moving, and making sure we're advancing the conversation and giving entrepreneurs and innovators a sense of what the direction the country is going to take from a policy perspective. So we have to balance if you don't do something now, we're going to move overseas. I take that with a grain of salt, but we have to have the conversation. We have to engage. We have to come up with a framework and set a timeline and a pathway so that these innovators, these entrepreneurs can do what they do best. And I think we're on that path. This is certainly a step in the right direction. It's a very positive step, and I think if we continue to do that, we'll be able to preserve these entities, these companies, these entrepreneurs within the U.S.
Fantastic. I really appreciate it. And I want to echo what Senator Klobuchar said. Thank you, Senator Gillibrand, for leading such a great team and a great victory. I have played women's softball, congressional softball, for many years. I was not able to make the game last night. We lost all the years that I played, and they won last night. So what's the common denominator there? But anyway, thank you, Kirsten. Great victory. Thank you, Chairman.
Well, thank you so much. And I'm going to turn to the winning pitcher of last night's game and a leader in this, Senator Gillibrand.
Thank you, Madam Chairwoman. Thank you to Amy, and thank you to Joni. Amy's our commentator, so she keeps and the crowd very lively, which is very important. And Joni has the best arm of the whole team, so you better come back next year so we can keep our winning. Chairman Benham, thank you so much for your leadership on this issue. Thank you for being willing to work with this committee, for you being willing to work with me on my legislation as well. This bill that we are looking at, I think, can be transformational. I think it is timely. I think it is urgent. I think it is necessary to create stability in a market that is growing. And I talked to a lot of colleagues about cryptocurrency, blockchain, Web3, and they say, well, is this going to go away? It's here for good. It's part of the world economic community. And the question that we have as a committee right now is, are we going to be part of the solution or are we not? And what is needed so much right now are rules of the road. We just need rules of the road. So market participants, so innovators, so businesses can have basic clarity on how to create their businesses, what level of oversight and accountability will be effective, how to create basic safety and soundness, how to create consumer protection. And you being part of this process has been absolutely essential to getting this bill written and to getting where it is today for the committee. So I'm very, very optimistic. I would like you to continue along with the line that Senator Ernst started about why is this relevant now? This bill takes jurisdiction over the commodities part of cryptocurrencies. Some cryptocurrencies are securities. Digital assets can take many forms. SEC has a regulatory responsibility. Cftc will have a regulatory responsibility. IRS will have a regulatory responsibility. And so will thoughts and ideas on cybersecurity, which I'll address after this question. But I'd like you to talk about is how does this bill fit into the broader framework? Why is getting this bill done now so essential? And why and how does getting this bill done now allow us to build on it to do the rest of the regulatory frameworks, to then go and look at the banking committee and try to do stable coins, go and look at the banking committee to try to get SEC regulation for those digital assets that are securities. Talk about why this piece matters now.
Senator, thanks for the question. You rightfully point out that this is one piece of the puzzle. We all have a role to play. We all have our pieces to contribute to the larger puzzle. I've been lucky to participate in the Principals Working Group, the Financial Stability Oversight Council, other international fora, and this is a big issue. You mentioned stable coins. This is a predominantly prudentially banking regulated issue. The security tokens, there are thousands of security tokens that innovators are creating and that we need to address. There are issues around payments, custody, settlement, so many different elements of this larger digital asset ecosystem that in many respects is interconnected. As much as their own little silo, they're all interconnected. I think this is an important bill because you expressly outlined Bitcoin and Ether and commodity tokens that will be a significant majority of the digital asset marketplace. And I think it will push the conversation forward so that we can continue to have policy around the different areas of the digital asset space clarified and complete. Because as much as this will bring clarity, transparency, and most importantly, as you point out, customer protections to this particular market, which is significant, the other elements need to be completed too. We need to complete the larger puzzle because if we're going to see advancements in the technology and the innovation, coupled with the customer protections, the market resilience, and ultimately financial stability, depending on the size of the market, we need to have this patchwork all plugged together so that we have the full lens into the space from a regulatory perspective and from a prudential perspective.
Thank you, Mr. Chairman. And along the lines that I mentioned on cyber, when I first became involved in this issue, it was through my role on the Intelligence Committee. And so obviously addressing things like cyber threats, fraud, theft, privacy breaches, and other technology-based crimes facilitated through Web3 applications by foreign adversaries is top of mind for me. Can you talk a little bit about the work that you and your agency are undertaking to be ready to address these types of threats and what needs to be done in the future to ensure security of the commodities market?
Thanks, Senator. Cybersecurity is top of mind at the agency right now. We are a financial market regulator that has systemically important registrants. As I mentioned in my earlier responses and in my statement, we have core principles which drive our rules and regulation. The core principle around system safeguards directly relates to cybersecurity. We have to build operational resilience within the institutions, the regulated institutions. Thankfully, the DCCPA addresses this specifically, prescriptively mentions cybersecurity. So we're leveraging the tools, the expertise we have. We understand that we're going to have to up our game because from a markets perspective, the cyber resilience and cyber issues are largely the same. But this technology, specifically the custody element, the that how do we hold these tokens and the unique nature of the technology is going to require some deep thinking. It's going to require new hires and new expertise in the space. So those are the areas that I'm concentrated on. Using the resources that the bill provides will be critical to ensure that we can recruit, retain, and build out that infrastructure so that we have a cyber resilient system. As we've seen in the past with Colonial Pipeline or others, digital assets will be a vulnerable point, will be a touch point for bad actors to try to attack the U.S. through different systemically important infrastructure.
Thank you, Mr. Chairman. Thank you, Madam Chairwoman.
Thank you very much. Senator Tuberville.
Oh, thank you very much, Madam Chair. Senator Bozeman, thank y'all for doing this. We need this. We need this bill. We need to regulate. We've got people out there investing in this, don't have a clue what they're doing, including me. There ain't a handful of people in this room right now that really understand what we're talking about. And I've been to hours of seminars and read books, and it's complicated. And we need to help the American people, so thank y'all for doing this. And Mr. Chairman, thank you for being here. Thank you for being accessible and your hard work that you're doing. Some of your counterparts in some of these other agencies could learn from you and your accessibility. But just a few questions. You know, I recently learned that over 90% of all crypto trades are executed outside the United States. Our country dominates, obviously, equity and bond and derivatives trading. Why are we so far behind in this?
Senator, as I was talking to Senator Ernst, it's a great question. I think we are moving at a good clip, but we're certainly not moving as fast as others. And I think we have to balance the need to preserve the financial integrity, the financial resilience that has made our capital and derivatives markets the best in the world, but also making sure that we're giving a clear sense to the marketplace that we're moving forward. There are several jurisdictions around the world which will naturally use this as an opportunity. They think that this is a way to increase economic development so that they're going to either lower standards or lower their sort of regulatory bar so that they have more individuals or institutions coming into their jurisdiction, and that's fair. But I think from a U.S. perspective, given our size, given our legal structure, and given the accountability through enforcement, we can move at a clip that's safe, that's cautious, that's thoughtful, but has to be deliberate. And I agree with you, and I get your sense that we need to move forward. This is a step in the right direction, but we need to continue this conversation and see this through the finish line so that we have that certainty for market participants so that they can start the business there. And that statistic which you named, having that volume greater outside of the U.S. as opposed to inside of the U.S. can be flipped.
You know, other countries are starting their digital currencies, including our biggest adversary, China. What do you think about that? And what is their regulatory system going to look like? Have you read anything on that?
Senator, you know, I certainly recognize that, and I'm very aware of what's going on. There are a number of issues that, or approaches, I would say, that China is taking that I don't think we should or are taking here in the U.S., specifically around privacy issues. But with that, I know the Federal Reserve and the chairman, Chair Powell, is working very carefully and thoughtfully, not unlike what I said earlier, to contemplate the idea of what a digital dollar would look like. It is a balance. It is a lot of technical issues, monetary policy issues, and infrastructure issues that have to be really worked through thoughtfully and comprehensively before we can push that out in either a beta mode or in full. So I think we're moving at the right clip. It's got to be cautious, but we're keeping an eye on the ball, engaging, and moving the conversation forward.
If we were to pass this bill tomorrow, do you have the assets to implement this?
Senator, one of the great elements and provisions of the bill is the user fee, which Senator Bozeman pointed to, the chairwoman did as well. This is a critical component of this bill. So with the user fee that's exclusively focused on the digital platforms, we would be able to implement the bill.
Yeah. How's your relationship with the SEC?
Historically and presently, it's always been very positive. I speak regularly with Chair Gensler, and I know my staff does as well. We have to work together. We are building off a relationship that's decades old. And in order for us to serve customers, taxpayers, and market participants, we have to work together well, and I think we're doing a good job at that.
I think one of our biggest protections in this area is going to be education. People really understand what's going on because, as I said earlier, a lot of us are behind. you know, and it's pretty complicated, obviously. So I'm starting to see digital ATM machines in my state. What's your thoughts on that?
Senator, and I do want to commend the Alabama Security Commission. You know, they've been very forward-thinking and very thoughtful about, obviously, at the state level, protecting customers, and we work very closely with them. So I appreciate that relationship. There are a lot of things emerging. I've seen the same sort of ATM machines that you are pointing out. And yeah, this concerns me. I think on the one hand, we have to let individuals make choices. But I think collectively, as policymakers, we have to make sure that the individuals are informed. They're informed with facts, and that they can make the most informed decisions about what they're doing with their capital and how they're allocating it. And that's what concerns me today, is that we're not doing that right now because this market is operating in the shadows. We do our best at the CFTC to put advisories and customer alerts on our website, but it's simply not enough. We have to leverage states and work with their individuals who are really boots on the ground to get individuals at, VFWs, town halls, churches, schools, to get information, to have access information so that when they go to that ATM, they know what they're doing and they can make the most informed decision. And we're not there right now, but this bill takes a step to accomplish that.
Thank you. And I'm like Senator Gillibrand. People think this is a phase. This is not a phase. This is not going away. And you're at the head of this, and we hope we can help you in any way. We're behind you 100%, and we just want to continue to be educated and marketed the right way and regulated. I think that's going to be a big key. So thank you, Madam Chair.
Well, thank you, Senator, and I agree that's why we have the legislation. It's our job to make sure that those things are in place. So Senator Smith and then Senator Fisher.
Great. Thank you, Madam Chair and Ranking Member. And I want to just let you know I appreciate the work that you're doing with this bill to address the regulatory gaps that we have, particularly when we're thinking about digital commodities. It's interesting, along with my colleagues, Senator Brown and Senator Warnock, I have the privilege of sitting on both this committee and the Banking Housing Committee. And in fact, Chair Gensler is testifying in front of the Banking Committee as we speak, which is where I'm going to be going next. Not on this topic specifically. But I do think that this gives us a unique view, an important view, not only of the spot and derivatives markets for digital asset commodities, but also the market overall. So I'd like to dive in a little bit on how this can work together. And I appreciate what you're saying, Chair Benham, about the importance of having a comprehensive approach, and also the fact that, your agency has worked with SEC together for many, many years. But could you just talk in a little bit more detail about how you see, with this bill and the needs for regulation and other capacities around digital assets, how you see that working together, coming together?
Well, Senator, it's a good question, and I think, as I was pointing out to Senator Gillibrand, this bill is a huge step in the right direction, but there are missing components. There are other parts that we need to address around stable coins, around the securities law, around payments and settlement and whatnot. But I think it creates clarity around the commodity markets and around the definition of what a digital commodity is. And just by virtue of that, and I think the definition is drafted quite well because it very clearly talks about a digital form of personal property. It excludes physical commodities. It excludes securities. And it excludes dollars, or essentially a digital dollar, something that's backed by the U.S. government. So with that framework, we then have at the CFTC a sense of what constitutes a digital commodity. In the inverse, my colleagues across town or at prudential regulators could then use this bill as a marker for how the rest of the patchwork or the puzzle may look. And I think that's extremely helpful in the process of identifying what's a commodity, what's a security, what's a stable coin, and how everything should fit within each different regulator that oversees financial markets.
So what would be, just as an example, what would be the implications of having, you have one platform, you have digital assets being offered on that platform side by side that are regulated under different regimes? Are there implications to that? Is that something that we should be thinking about?
Well, it's in many respects. So you would probably have duly registered platforms. So in a case where you had a security token and a commodity token, the trading platform would be regulated by both the CFTC and the SEC. depending on how the platform wanted to list the contracts, they would either be siloed within a commodity space, a security space. You could potentially segregate the customer accounts and the custodian sort of services that you're providing to the client. Alternatively, you could have a single account, an omnibus account for a client that services both the security side and the commodity side. It may sound complicated, but with the efficiencies of technology and, quite frankly, the experience we've had in the swaps market, we have security swaps, we have commodity swaps, we have security futures, we have commodity futures. We have done this before. We have dual registrants from investment advisors to broker-dealers and future commissions merchants. So we're not reinventing the wheel. There's a level of complexity we can certainly figure out in partnership with the private sector, but of course with our sister agency to ensure that we're doing it in the most efficient way, but ultimately the most productive way from a customer protection and market resilience perspective.
So your view is that while there might be some complexity to that, that's complexity that can be addressed through good coordination and good coordination between the agencies.
Absolutely.
Yeah. As I understand it, the bill takes the regulatory structure for commodities that exists and applies it to digital assets that are being marketed to retail investors. So could you talk about, your agency doesn't work directly with retail investors. So could you talk about how that framework will apply to retail investors and how you can address how that works for retail investors?
Yes, you're absolutely right, Senator, that the majority of our investors, our customers, our market participants are institutional. We do have a fair amount of retail participation in our market. We work closely with the National Futures Association, which is an SRO, which is contemplated in this bill, to make sure that we have boots on the ground, that we have appropriate disclosures. We have the core principles, which I've mentioned a couple times about, preventing contracts that are readily susceptible to manipulation, protecting customers, making sure that information is getting to customers through disclosures. I would say that as you sit on both the banking and this committee, this distinction needs to be drawn, and I've said this before, commodities have a very different disclosure regime and requirement than a security does. The security requirements require, in good faith, this bridging of information gaps between an issuer of a security and an investor. That's because there's management, there's a centralized management, there's a financial statement, any of these things that we see in reports from the SEC, quarterly, annual, or periodic. That doesn't exist on the commodity side. What we have to do is protect markets, make sure markets remain transparent, fair, orderly, and that customers understand market-based risk as they decide how to allocate capital.
Thank you very much. Thank you, Madam Chair.
Thank you. Senator Fisher.
Thank you, Madam Chair. We've seen reports that the SEC Chairman Gensler has said he's working with the Cftc on formal memorandum of understanding, which would create one rule book between regulators for the regulation of digital assets and digital asset exchanges. So my question to you, Mr. Chairman, how important is it that we have that one notebook between all the regulators?
Senator, thank you. It's a great question. I think it's important that we have a mutual understanding between regulators, especially the two market regulators, us and the SEC, about how we're going to collectively regulate markets. Regardless of the type of market or the financial asset, there always is an intersection between the two regulators because you're going to have duly registered entities or individuals. So it is very important that we have this mutual understanding in the form of an MOU or just a handshake agreement in certain times, because we need to know what and how we're going to contemplate these different financial assets within the context of the law. That said,
are you working on an MOU right now?
An MOU. I know, Chairman Gensler and I talk frequently. We understand what may occur within the context of the securities laws if entities were to be registered as securities platforms or securities ICOs. And if there is a situation where we need to work on an MOU type document, I certainly would be open to it and willing to make sure that it works for market participants.
Have you reached out at this point to try and do that? Does Congress have to provide guidance on that? Are you able to do that on
No,
your own?
yeah, we're able to do that. We have several MOUs between the two agencies on enforcement matters or other matters of mutual interest.
Okay. Nebraska passed a law that was introduced by our newest Congressman Mike Flood, when he was in the Nebraska legislature, and it allows digital assets depositories to be created, which have allowed state-chartered banks in Nebraska to offer services to customers who have those digital assets. Nebraska is just the second state to pass that legislation. But as we see these digital assets grow, questions will continue to be raised about how they should be regulated and the role that state regulators play alongside the federal regulators, particularly as it relates to protecting and educating investors, as Senator Tuberville was referring to. Can you discuss your views on that relationship between the state regulators and the CFTC, please?
Thanks, Senator. I would say, as a former state regulator myself, having state regulators is so important as a matter, and I use this phrase with Senator Tuberville, boots on the ground, right? We in Washington don't have the capacity or the resources to have that comprehensive reach across the country, whether it's in Nebraska, California, or any other state. And the state regulators play a key role, and that partnership is so critical to make sure that those individuals at the state regulator are touching individuals at the local level, at the county level, or the district level. So we have a very close relationship through MOUs, actually, with NASA, which is essentially a National Association of Securities Regulators. Crypto is top of mind right now, and it has been for several years. I think the bill does a very good job from a markets perspective in preempting states from registering the entities that the bill contemplates. But what it does do is it preserves states' authority over anti-fraud, which is a critical authority for states' attorney generals to have for bad actors at a local level. So we will continue to use the relationships, the existing relationships we have with state regulators, and understand that they play a critical role in making sure that information and disclosure and education is received by local investors, but also those protections around fraud are preserved.
Have you had any contact with states on the at this point in time? Has Nebraska reached out to you, or the other states who may be looking at passing similar laws? Have they contacted you at all on this for any kind of guidance?
So I've spoken with the Alabama State Security Commissioner, and in part because we've known each other for a number of years in my professional capacity and his as well. He's also the president of this association, I said, the National Association of State Securities Regulators. So he may act as the sort of voice for the larger association in each individual state member. I did speak at the annual fly-in they had a few months ago, but I have not heard from Nebraska. I would certainly welcome the opportunity to build a relationship, to talk with them, to learn what they're doing, and to support them with the resources and the expertise we have.
Okay. Thank you, sir. Thank you, Madam Chair.
Thank you very much. Senator Durbin.
Thank you, Madam Chairman. Chairman Bainum, thanks for coming here. Representing the city of Chicago, I'm more familiar with the CFTC than some members, and I think you do a great job. In fact, because of your good work, we've been able to establish global leadership in many areas, particularly when it comes to the mercantile exchange and futures market. People trust it. It has a level of integrity that makes a difference. There is global competition, but we seem to do pretty well in that competition. And the question is whether or not we can establish the same standard of integrity when it comes to this whole crypto world. I was surprised in preparing for this to learn that 1 in 5 Americans has invested in or traded cryptocurrency. Your testimony notes the fact that a significant number of these investors are lower income individuals who took quite a hit recently. It's no wonder that the average American is interested in this. After all, respected investment advisors like Matt Damon and Larry David have told them this is a good investment. Everybody's doing it and everybody's winning. But we know the reality, and you pointed out the reality. That isn't the case when we look at the record. Over the last year, the value of the crypto market has fallen below $1 trillion, losing about 70% of its value. Bitcoin alone has seen its value plummet between below $20,000 from a peak of $67,000. In June, Celsius, a crypto platform, suspended customer withdrawals and transfers, filed for bankruptcy. In May, the quote, stable coin, Terra collapsed, resulting in a $300 billion loss across crypto markets. Yet it was marketed as as a stable coin. Don't get me wrong, there is risk and speculation, and it applies to a lot of different circumstances. But lucky for us that cryptocurrencies have not been inextricably tied to our banking system, or a $2 trillion loss would have been felt in a different way. And now we have companies like Fidelity saying they are going to include bitcoins and cryptocurrency in retirement accounts. If we went through another meltdown as we did this last year with retirement accounts and life savings at stake, it would have a much greater impact. I would say my concern is this. I'm glad we're talking about regulation. We have to have it. But I worry that we are doing enough to salve our conscience, that we're doing something, but not doing enough to put up guardrails and stop signs on the Crypto Express. In this term, regulatory certainty, I've run into that before as a term, that if we don't provide regulatory certainty to this industry, they'll leave. They'll go to Malta or El Salvador or Portugal or somewhere. Really? Do you think that's a possibility?
It is, but it's not a concern of mine. And Senator, I appreciate the point. It's what I said to Senator Ernst. We in the U.S. have to balance our approach to regulation. And we've done this very well for decades. We have to be deliberate, we have to be cautious, we have to be patient, and instill the principles of regulatory foundations that have made our capital markets, our derivatives markets, including the Board of Trade, the best in the world. But I do think, coupled with that caution and deliberation, we do need to move forward. We need to engage. We need to understand that this is a new technology that's disrupting financial markets.
How much money does CFTC need to regulate cryptocurrency?
Senator, I think about a year ago, I think it was my November hearing before this committee, it could have been February, and I apologize for not knowing specifically. I said $100 million. I used that number because that was approximately the number that we received over the past few years since the financial crisis and what our funding level went prior to the financial crisis to after the financial crisis. But in an effort to get a more specific number, I had my staff work on this exercise specifically for a number of months. We've come up with $112 million over the first 3 years, divided not equally. We would be weighted on the front end of the 3 years. This would be for rulemaking, this would be for hiring, this would be for training, expertise, and this would be with outreach.
What's your current annual budget?
Current annual budget is $320 million.
So you're talking about a substantial infusion through the user fee of $112 million.
$112 million over 3 years. The first year would be about $40 million. So
really?
Yeah. And
so
we did calculations based on the rulemakings and some of the reports that are due, and then the engagement with the industry.
Well, I would like to talk to you about that because I honestly believe that you're lowballing it. That if you're serious about regulation of industry where 1 in 5 Americans now has invested and had some risk, and we're now getting into retirement accounts and 401ks and the like, and the major brokers like Fidelity and others are starting to include this in their plan. There's a lot more exposure and a lot more risk than just a year or two ago.
Senator, I welcome the conversation. We did sort of off-the-cuff analysis based on examinations of who's registered with FinCEN and just doing a survey of markets. This is certainly not a hard number, and you may be right, and I certainly would welcome an upward movement of that funding level, but I did want to come back with some evidence to support a number as opposed to just saying $100 million, which is what I did last time. But time will tell, and I don't know how the market will either consolidate or grow after this bill would be passed. So it's hard for me to give an exact number, but I just wanted to do my best to defend a number that I'm sharing with the committee.
And this number, whatever it may be, is going to be generated from the crypto world in a user fee.
Exactly.
Thank you, Madam Chair.
Thank you very much. Senator Thune and then Senator Booker.
Thank you, Chairman Stabenow and Ranking Member Bozeman, for holding today's legislative hearing to consider the Digital Commodities Consumer Protection Act. I also want to thank both of you for your leadership on this legislation and on the responsible regulation of digital commodities. Technology continues to transform digital commodities, and it's critical the federal government has the proper tools to regulate this growing market and to provide certainty when it comes to digital commodity platforms, which is why I'm an original co-sponsor of the bill that we're considering today. It would clarify the regulatory uncertainty surrounding cryptocurrencies and give the CFTC explicit authority to establish rules and regulations to oversee digital commodities and establish guardrails for the market, which I think we all agree needs to happen. So I want to thank all the witnesses who are here today for your input. Look forward to working with my colleagues on this committee to advance what I think is very important legislation. Mr. Chairman, in your testimony, you highlighted the regulatory role CFTC has played over the digital asset commodity market in recent years. Could you sort of walk us through, I don't have a lot of time, fairly quickly, through CFTC's experience and successes in regulating digital commodities?
Thanks, Senator. Yeah, we've been overseeing this market through mostly an enforcement mechanism since 2014, utilizing our fraud and manipulation authority. We've brought over 60 enforcement cases, some as large as $1.7 billion, $100 million, $40 million, against some of the largest incumbent crypto firms. We, since 2017, have had listed futures contracts relating to digital assets, Bitcoin, Ether, and others, and we're continuing to see, even in the past few years, native or incumbent crypto firms purchasing CFTC-regulated entities or licensed entities. So the move is swift, it's quick, it's forcing us to learn, to up our game, and to leverage our expertise, and I think that puts us in a good position to implement this bill and oversee the market.
So given that, just what you shared, the CFTC's recent enforcement actions and efforts, what's your response to concerns that the CFTC is not equipped to play the lead regulatory role for digital commodities?
Well, I don't think that statement's really backed by facts. I think if anyone took some time to look at what we've done over the past few years, going back to 2014, I shared with Chairwoman Stabenow some of our enforcement statistics writ large. We're one of the toughest cops on the beat across the globe. We have expertise because of our experience with this technology, and I think with the user fee that's included within the bill, we would be able to leverage that authority, hire the right individuals, train existing individuals, and really hit the ground running and do what we needed to do.
Let me ask again quickly, and I know that you've probably addressed this issue already, but where would you say the United States ranks globally in terms of digital asset and blockchain technology, and if enacted, what effect would this legislation have on U.S. competitiveness in this space?
Senator, naturally, because of the size of our markets, the capital available through venture capital and fundraising and private equity, we're always at the top. But I think there are other jurisdictions that have taken a very aggressive approach to this technology, hoping to sort of capture the innovators within their jurisdiction. As Senator Durbin pointed out, I think that comes with risks, and that's not something I support, moving or arbitraging our regulatory system. I think we do it very well here in the U.S. of moving cautiously and deliberately, but as I said, we have to move forward. I do think this bill, if passed, would create the authority, give regulatory certainty, and I think give incentives to innovators and entrepreneurs to stay here in the U.S. and leverage the venture capital, the private equity, and the legal infrastructure, the enforceability of the law, which really is one of the most important things of all within global jurisdictions, and elevate our status within other countries regarding this technology.
So one of the objectives of the bill, and we all talk about this, is how essential it is that there be strong, robust consumer protections to protect customers in the digital asset marketplace from fraud manipulation. Can you kind of just speak to how this legislation would help build upon the CFTC's already robust customer protection enforcement actions?
Yeah, Senator, it's a great question, but it really is built on multiple layers. It's the core principles, which is reporting, record keeping, it's conflicts of interest, it's cybersecurity through system safeguards, it's prohibition of listing contracts that are susceptible to manipulation. It's this baseline foundational level that pushes us towards writing more prescriptive rules, and then enforcing those rules through inspections, examinations, investigations, and then ultimately, if someone breaks the law, keeping them accountable and making sure that we're deterring future action. So it's a series, it's a layered customer protection regime. It is largely replicating what we do now and what's been very successful for decades. And I have no doubt that this regime that we do in traditional derivatives could be applied as equally and as successfully in digital assets.
All right, thank you, Madam Chair. My time's expired. Thank you, Mr. Chairman.
Thank you very much. Senator Booker.
Madam Chairwoman, Ranking Member, I'm really grateful for your leadership in this space, and I'm honored to be a partner on what I think is an important bill. I just want to say, first and foremost, it's good to see you, another bald Jersey boy, doing okay. And so, just really quickly, I'm really optimistic, not necessarily about the coins and the commodities, but the technology underlying all of this opens up a whole new realm of possibility for Web3 when it comes to blockchain. We have some real issues and concerns right now that I think this bill addresses. We have seen scams being perpetrated by outright fraudsters taking advantage of eager investors. We've seen risky projects with inadequate disclosures, not giving consumers chances to accurately evaluate the assets they're purchasing with their hard-earned money. And we've seen these advertisements, which some of my colleagues have already talked about, promising guaranteed profits and almost seeming like hucksters as they put forward. We don't have significant guardrails right now. We don't have transparency that we need right now, and we need better regulations. And so there's only three things to do as Congress. We can do nothing, which would allow a lot of this to continue. There's some people that want to create rules that basically make it illegal or impossible for everyday people to access tokens, strangling a market. We can undermine the strong securities laws and customer protections that already exist in the financial sector, opening floodgates that would enrich a select few, creating chaos and uncertainty for businesses and regular people alike. Or we can do what this bill does, which is dig in with the goal of allowing this space to thrive, for innovation to occur, but also give solid protections that would curb scams, frauds, increase transparency, accountability, and increase the safety and the strength of our financial system. That's why this bill, to me, is so utterly important, and doing nothing is unacceptable. And so I just want you to address some of the criticisms I hear out there, specifically about the CFTC. Some people say that this is just going to be some kind of light touch regulation in the crypto market without the real capacity to hold bad actors accountable and brings stability. Chairman, what do you have to say to those who think the CFTC with this legislation would bring a regulatory touch that would be too light, and how you as chair will work with Chairman Gensler and other commissioners of the SEC to make sure that there's strong regulatory provisions in place?
Thanks, Senator. I said this to the chairman. I could unequivocally say, our rules are based on customer protections. The data, if someone took time, who's drawing this narrative that we're weak or light touch, if they took time to see what the CFTC does, if they took time to examine how our rules are structured and what they're based on, and the success of the markets, which Senator Durbin was pointing out, they would know that we are one of the toughest cops on the beat in the world, and we are known for that. Our enforcement statistics speak for themselves. We're turning 6 times what our budget is every year for the past 10 years. And these are the individuals within the agency that, these are sophisticated contracts too, whether it's swaps, futures, or options. I mentioned a case against a commodity trader. Very, very sophisticated trading strategies, manipulative trading strategies to create some arbitrage or some net benefit between cash and futures markets.
And just because of sake of time, with the extra resources as well, you would be able to do even more significant enforcement as well. I just want to shift to another big criticism that I hear a lot about the energy consumption involved in cryptos. Even though some people are moving away from proof of work, I just want you to touch on that real quick about, obviously President Biden has tried to address this. What would you be able to do as a result of this legislation even more so to deal with this?
Thanks, Senator. I think it's, as a first starting point, the bill is very effective in requiring us to write a report. It requires us to consult and work with other regulators within the U.S. government, specifically those who have expertise in physical energy markets, do a tooth and nail examination of what the energy consumption is, how it relates to the output and the utility of the technology, and then come back to this committee in 6 months with a report of what our recommendations are to either create a disclosure regime or incentives for folks, as you mentioned indirectly, to move away from proof of work to move to proof of stake or other methods to reduce carbon emission consumption.
So the last thing I just want to really cover really quickly with you is some part of the bill, and I've been so grateful to the chairwoman for allowing me to help to shape this. But I'm concerned about equity issues that are out there, the disparities in wealth that we have in this country that are persisting. Women, African Americans, they're overrepresented right now in participating in the world of digital assets, which is concerning given the lack of regulation that we're looking at. But it also is something that I think could actually help to create more opportunity for democratization of wealth in our nation. And so this bill directs the CFTC to examine racial, ethnic, and gender demographics of customers participating in the digital markets and to use that information to inform your rulemaking. Do you want to comment on that provision of the bill real quick for me?
Yeah, Senator, I'm extremely excited about it, and I'm excited, I'm very proud that I created the first Chief Diversity Officer at the CFTC a few months ago. We have moved the Office of Customer Education within our Public Affairs Office. We now have an infrastructure to leverage what the bill requires us to do to have a wider outreach to communities, lower income communities, historically marginalized communities, and get boots on the ground to educate, to inform, to do the outreach so that we understand where these pockets of speculative investors are, where these individuals who are risking capital without being informed about the risks associated with this technology. It's going to be a priority of mine. Certainly look forward to working with you, but I think we're in a good place right now with some actions that have been taken in the past year, and this bill's authority, coupled with the user fee, should really springboard us to get information out to consumers.
Thank you. Damn it, you make Jersey proud. You're not quite Bon Jovi Bruce level, man, but you're climbing the hill. I'm not going to be able to stay for the next panel because I've got a sickle cell work to do. I just want to say thank you, Chairman. The next panel doesn't have quite the Jersey authenticity, but there are some really good folks. And
Really
I know there'll be
good.
great conversations with you all here. So thank you.
And thank you so much for your input in general on the bill, but specifically on those provisions that are very important as we go forward to evaluate impact. So thank you very much.
Thank
for
you.
all of your leadership. So Senator Hoeven.
Thank you, Madam Chairman. Appreciate very much, Chairman Benham. Thanks for being here. Appreciate it. So now you're going to be regulating in the spot market versus futures. Can you tell me what your thoughts are in regard to that? Is that going to make a difference for you in a significant way? And does it portend other future regulation in the spot market?
Senator, thanks for the question. I don't think it portends future regulation in the cash market or the spot market. I think, as I've said a few times, this particular commodity market is unique as it relates to traditional agricultural, energy, or metal commodity markets because it's highly speculative and it's retail oriented. And that's why I think we have a very important role to play in this specific commodity market as compared to some more traditional.
So how should this, thank you, so how should this work? I mean, there's going to be multiple agencies now that have a role. What should that look like? Not just your role, but how do you interface with others so we don't end up with one of these bureaucratic mazes that nobody can figure out what's going on or who's responsible for what, which is not only difficult for the providers, but for the consumers.
Sure.
What should it look like in your opinion?
Senator, I think it needs to look like what we do now in traditional financial markets because, and I'll just use our sister market regulator agency, the SEC, as an example, but we have relationships with the banking regulators because we have duly registered entities as well. But we have been forced to work together for the better part of 50 years with them because the registrants, the market participants, have access and intersections with both our markets. They're duly registered as advisors for commodity pools or investment pools. They're duly registered as broker-dealers or future commissions merchants. So we have the framework and the foundation to do exactly what we've been doing for decades in this space, and I have no doubt that we'll be able to do it successfully. There's goodwill, good faith, we can get to it, and I think ultimately the reason why I think it's going to work well and the reason why I think it's worked well is most clearly demonstrated in the fact that the U.S. has the strongest, deepest, largest capital markets and derivatives markets. If we didn't do our job well from a regulatory perspective in matching these differences, we wouldn't have those statistics and that data to support it.
Are you interfacing now with those other agencies that will be involved in the oversight regulatory function? And is there a blueprint as to how that interface will work? And are there other bills with other committees of jurisdiction that you are coordinating with this legislation?
Senator, I'm mostly working, I have most contact with the SEC and Chairman Gensler because of the relationship we have through our markets. I work closely with all other federal regulators, both from a professional level, it's important to do it, but through the President's Working Group and the Financial Stability Oversight Council. We are working on several projects focused on the digital asset area. President Biden's EO has forced us, thankfully, to work on these issues specifically. We will continue to do it. We don't have any set structure necessarily now because there's a little bit of a vacuum in terms of what regulation might look like. We've seen several bills, most notably on stable coins, some on cash markets, but this, as I said to Senator Gillibrand, is a step in the right direction. It needs to be moved as quickly as possible. One piece of the puzzle, but I think as that puzzle becomes more clear and we see what the landscape is going to be, then we'll be able to credibly move forward as regulators and lay out the plan of how we're going to work together and how we're going to put this out in an effective way.
But who legislatively makes sure that that package of legislation pulling in, all these agencies actually works?
Senator,
who does that versus, various committees of jurisdiction, various agencies, each kind of doing their thing?
Yeah. I would say the best blueprint to look at now, the most recent one is Dodd-Frank and after the financial crisis. This committee played the most important and the sole role in Title VII, which was the derivatives title, but there were multiple titles to the Dodd-Frank bill which affected several financial regulators, which we work currently with.
Yeah, well, not everybody's a fan of Dodd-Frank or the CFPB, so I'm not sure.
I appreciate that, but it's been still a blueprint of how Congress passes the law, multiple jurisdictions, multiple agencies, and then we need to work together to implement the law in an effective way with appropriate oversight on a continual basis.
Well, I do think that coordination is important to get particularly with the complexity of cryptocurrency. And, we're all still trying to understand it, right?
Agree.
One other question, I know the Merck is concerned about, but you have not used the user fee concept before. And obviously, that's something we're very familiar with because of FDA. I serve on ag appropriations, so we deal with that all the time. And it has good aspects and has some that aren't as good. What's your thought on now for the first time actually using that user fee concept?
I think structurally it should not be very difficult to implement. I think it's critically important that the user fee is structured in a way where we have to work with appropriators to set the level of what we can assess in terms of fees. So we won't be able to just assess fees individually or independently. We have to work in coordination, which I think is consistent with most user fees assessed right now. But overall, Senator, I would say it's critically important. We will not be able to do the job the bill requires us to do unless we have the resources to do it.
Thank you. Appreciate it. Thank you, Madam Chair.
Thank you very much. And seeing no further questions from colleagues for Chairman Benjamin, we want to thank you very much for joining us today. Look forward to continuing to work with you. We'll take a moment to bring up our witnesses, our second panel. We're so pleased that all of you are with us. I will indicate that we will see a vote starting shortly, which will just mean you'll see us coming and going. It doesn't mean that Senator Boozman doesn't like what you're saying, or that I don't like what you're saying. That we will be going back and forth, and probably have other colleagues as well. So I don't believe that has started yet. So welcome. Appreciate all of you taking the time to be with us, and I will begin our introductions. First, I want to welcome Todd Phillips, the Director of Financial Regulation and Corporate Governance at the Center for American Progress. He has experience in both Congress and the executive branch, having served as an attorney for the Federal Deposit Insurance Corporation and the Administrative Conference of the United States, and on the staff of the Oversight and Reform Committee of the U.S. House of Representatives. So we welcome you. Sheila Warren is the CEO of the Crypto Council for Innovation, a digital asset trade association. And prior to joining CCI, Ms. Warren served as the World Economic Forum's Deputy Global Head of Data, Blockchain, and Digital Assets, with a focus on making the crypto industry more inclusive, equitable, and sustainable. So thank you so much for being with us. Christine Parker is Vice President and Deputy General Counsel for Coinbase, the largest US-based cryptocurrency exchange. Ms. Parker recently joined Coinbase from Reed Smith, where she was a partner in the FinTech practice group, and before that, practiced at Sullivan and Cromwell. And she's no stranger to Congress, having worked as counsel to Senator Schumer. We will not hold that against you, so welcome. Donnell Dixon is the CEO of the Stellar Development Foundation, a nonprofit that seeks to create equitable access to global financial systems. Before joining Stellar, Ms. Dixon was the COO of Mozilla and general counsel and legal advisor in private equity and technology. And I'm now going to turn to Senator Boozman for our last introduction.
Thank you, Madam Chair. Our next bipartisan witness is Dr. Heath Tarbert. Dr. Tarbert is the Chief Legal Officer of Citadel Securities, where he's responsible for the global legal, compliance, surveillance, regulatory affairs, and corporate governance functions for one of the world's leading market makers. Dr. Tarbert served as the 14th Chair and Chief Executive of the Commodities Futures Trading Commission and Vice Chairman of the International Organization of Securities Commission. During his tenure, the CFTC advanced 41 final rules and 21 proposals, 90% of them on a bipartisan basis. The CFTC also set numerous records in enforcement and more than 20 actions supporting liquidity and orderly trading. Before joining the CFTC, Dr. Tarbert was Assistant Secretary of Treasury for International Markets and served as a Supreme Court clerk, Associate White House Counsel, and Special Counsel to the Senate Banking Committee. Thank you for joining us, and thank you for all of the witnesses. This is just an outstanding panel. So thank you, Madam Chair.
Yes, thank you. And the vote did just start. Yes, absolutely. We're so pleased you're all here, and we'll now recognize each of our witnesses for 5 minutes. We welcome any other information you would like to give to the committee as well in writing. And so we'll begin with Mr. Phillips. Welcome.
Thank you. Chairwoman Stabenow, Ranking Member Boozman, and members of the committee, thank you for the opportunity to discuss the Digital Commodities Consumer Protection Act. I applaud your collaboration and the work of your staff in its development, and am pleased to support this bipartisan bill, which would provide much-needed regulatory oversight of the digital commodities markets. In recent years, crypto assets have grown significantly in usage and prominence in the economy and culture. The expansion can likely be explained not only by the innovativeness of the underlying technology, but also a general hype and narrative that crypto is revolutionizing the financial system. However, practices such as market manipulation, rug pulls, fraud, and outright theft plague crypto markets. According to one estimate, $2.9 billion worth of crypto was stolen in the first 4 months of 2022 alone. These types of problems pose significant risk to retail investors who in some cases invest their life savings into crypto, and might reasonably assume that they are protected from these threats by the routine federal regulations that apply to digital assets. When these harms occur is because there is regulation for crypto, largely either securities, a plethora of exceptions. The CFTC anti our commodities, exchanges, and the platforms that list them to be subject to SEC is a commodity, meaning that they apply. Today, Bitcoin % of the crypto market lack a regulatory. Further, although some courts have applied legal to declare securities, the case law is in its and courts deem some or most crypto assets commodities, federal regulators would be hamstrung to regulate them. Under these circumstances, the Consumer Protection Act provides a right-sized regulatory framework for decentralized digital commodities and grants the CFTC authority to oversee these markets. Most important, while the grants the CFTC regulates, The bill isn't anything that is a security. It would, appropriately, continue to deem securities with oversight from the SEC. It would implement for digital, including prohibitions listing assets that are susceptible from engaging in fraudulent trading. And these are protections that currently apply to further investors in securities have ready investors in crypto commodities to scour projects' Discord servers for unverifiable information. To a consolidated DCCPA would require crypto to disclose plain language information about listed investors by requiring platform assets not commingled with the platform's property. Update the bank protect would require the CFTC to help address the effects of crypto on both climate change and financial inclusion. The bill would require the CFTC to examine the energy consumption used in connection with the most widely traded crypto commodities and publish those estimates. This information could help incentivize token issuers to migrate to more energy-efficient blockchains and miners to utilize cleaner electricity as investors migrate their capital following the environmental impacts of their investments. The bill also would require the CFTC to study the participation of historically underserved communities in crypto markets and use this information to inform its customer protection regulations. Although my written testimony contains several suggestions for amendments, the DCCPA is a critical step in the right direction, and I applaud the chair, ranking member, and Senators Booker and Thune for developing this bill. I highly support the Digital Commodities Consumer Protection Act, and I encourage this committee in Congress to approve this bipartisan bill. Thank you. I'm happy to answer any questions.
Thank you so much. We'll now hear from Ms. Warren. Welcome.
Committee. Thank you for the opportunity to testify today on both the tremendous benefits and opportunities associated with the adoption of digital assets in the United States. I'm grateful for the engagement leadership shown by so many on this committee. There is a pressing need for regulatory clarity that promotes innovation while protecting consumers. The legislation being considered today can provide some of the certainty needed to help spur international economic growth, create jobs, improve financial inclusion, and enhance privacy and security. I'm pleased to represent the Crypto Council, a global alliance of industry leaders across digital assets and the Web3 space. We use an evidence-based approach to support institutions and leaders worldwide who are shaping and encouraging the responsible regulation of this innovation. Over the past 2 decades, my time as an attorney, entrepreneur, product builder, and NGO executive has focused on the intersection of technology, law, diversity and inclusion, civil rights, and Web3. Over the past 6 years, I've worked across 16 countries with leaders to advance the responsible and inclusive adoption of this new technology. Now, I see crypto as this generation's best chance of addressing inequity in current financial and technical systems. Crypto can provide a more equal playing field for people in communities that don't have meaningful access to these systems. And as we shift to a more ownership-based global digital economy, the building of an open and transparent regulatory framework is crucial. The DCCPA is a pivotal step in achieving the clarity and oversight that are greatly needed, and I applaud this committee for its bipartisan work on this legislation. Crypto improves efficiency and accessibility, reduces costs, and removes frictions from financial transactions. Cross-border payments underpinned by blockchains could save about $4 billion a year. For example, remittances comprise a $630 billion market globally, with high fees of 6%, according to the World Bank. By contrast, crypto service providers can process remittance payments with fees of 1 to 3%, a significant cost savings to consumers. Crypto also represents an unprecedented opportunity to increase financial equity. A Federal Reserve study found that nearly 20% of Americans have neither access to a bank account nor adequate access to financial services through other means. And this problem is significantly higher among those who are low income, less educated, or racial minorities. This is in part because these groups often don't trust traditional banks, as a recent FDIC survey found. By contrast, a 2021 Morning Consult poll found that in the United States, 37% of the underbanked population and 12% of people without access to financial services reported owning cryptocurrency. An ownership-based model is key to providing meaningful opportunities to these historically excluded populations. In the case of foreign aid, within days of the invasion of Ukraine, crypto was a catalyst and bridge to crucial financial support. Roughly $100 million in crypto donations enabled purchases of medical supplies and essentials before the bulk of foreign aid could arrive. And the reality is that crypto is global by nature. Simply put, other countries are not waiting for the United States to act. The European Union recently came to a landmark political agreement on their markets and crypto assets package. The United Kingdom has set out its plan to make the UK a, quote, global crypto asset technology hub. South Korea's Digital Asset Basic Act is set to be in shape by the first half of 2023. And it is clear that China is already poised to leverage its digital yuan as a tool to achieve its foreign policy goals in emerging markets and beyond. Relatedly, forward-looking regulation is paramount to national security. Financial services have always represented an important lever for the U.S. government, and risks will be heightened if U.S. companies become less predominant in this space. Proactive policymaking now is critical to maintain a competitive position. Of course, in an industry this complex, details are important. It'll be critical to thoroughly study things like decentralized finance or DeFi prior to including them in formal policymaking. It will also be equally important that the SEC, as we've heard, act as a regulatory partner to the Cftc, and that the question, what is a security, is definitively answered through the appropriate legislative process. I was particularly excited to see the report on historically underserved communities and the energy reports included in this proposal. I believe the actual facts that these reports surface will show that crypto can be a tool to support and impact critical policy goals in these spaces. Thank you again for the opportunity to discuss these important questions. I look forward to answering your questions.
Thank you very much. Ms. Parker, welcome.
Thank you. Good morning, Chairwoman Stabenow, Ranking Member Bozeman, and members of the committee. Thank you for inviting me to testify about the Digital Commodities Consumer Protection Act and the need for a comprehensive regulatory regime for crypto. My name is Christine Parker, and I'm the Vice President and Deputy General Counsel for Regulatory Legal at Coinbase. Prior to joining Coinbase, I was a lawyer in private practice where I focused on commodities, derivatives, and digital assets. I spent years advising clients on the regulatory and compliance obligations associated with Title VII of Dodd-Frank, as well as the Commodities Exchange Act more generally. I also had the pleasure of working for Senate Majority Leader Chuck Schumer for 5 years prior to joining private practice. I believe that we are at a crossroads when it comes to crypto. The U.S. government can either create a regulatory framework that embraces the transformative nature of crypto and protects consumers, or it can impose an unworkable regulatory framework that will push technological innovation and the jobs of the futures overseas, a trend that we are already seeing. I would caution members who are skeptical about crypto that the second path will lead to the unfortunate reality in which retail U.S. investors will continue to access Web3, but will be forced to do so through unregulated foreign companies that are not obligated to comply with the anti-money laundering, consumer protection, and safety standards that define U.S. financial markets. As the largest crypto trading platform in the United States, and the only one that is a U.S. public company, we are committed to the first path. That is why we applaud Chairwoman Stabenow, Ranking Member Bozeman, and the other co-sponsors for introducing a bill we believe will create a robust framework for the effective regulation of digital assets. I also want to thank the staff of the committee for their hard work and focus in solving the technological challenges presented in drafting this legislation. The current regulatory environment for crypto is complex and disjointed. At the federal level, the government has relied on laws that have not kept up with the technology. At the state level, laws and regulations for digital assets have emerged in recent years with little consistency across jurisdictions. The bill amends the Commodity Exchange Act to create a much-needed framework for spot markets for digital asset commodities. The framework would fill an existing gap in federal oversight and lead to a more consistent consumer protection across the country. The bill importantly draws on the CFTC's existing framework for regulating futures and derivatives, which is comprehensive and well understood. And to that point, I note that Coinbase operates a CFTC-regulated DCM, CFTC-regulated exchange, and we are hopefully a few months away from operating our own CFTC-regulated futures commission merchant. The bill defines commodities, digital commodities to include, but critically not limited to, Bitcoin and ETH. The bill does not, however, cut the Gordian knot as to what is or is not a digital asset security. That is one of the fundamental issues that remains unsolved today. What is a digital asset? Is it a currency, a commodity, a security, all of those, or something entirely different? At Coinbase, we employ a rigorous listing process to determine if an asset is legal, compliant, and secure before we list it on our platform. Key to that analysis is whether or not the asset has characteristics that would make it a security under U.S. securities laws. We have approved and currently list 219 assets for trading, and we are confident that they are not securities. However, this process is not scalable across the industry, and it forces Coinbase to reject many assets that we might otherwise lawfully be permitted to list. We believe the bill could be strengthened by further defining digital asset commodities to ensure assets that do not meet the definition of securities are regulated by the CFTC and not by enforcement through the SEC. We urge Congress to draw these distinct lines between the different types of digital assets to ensure they are overseen by the appropriate federal regulator. Statutory clarity would help existing and new market participants confidently offer new innovations to consumers in a safe and reliable way. In sum, Coinbase believes the Digital Commodities Consumer Protection Act creates a strong foundation for the regulation of digital assets. We understand the bill will continue to evolve, particularly as the full Senate considers the other issues and agencies that intersect with the regulation of digital assets. And we will continue working with all interested parties to pass a law as soon as possible in this important area. I look forward to answering your questions.
Thank you very much. And Dr. Tarbert, welcome.
Chairwoman Stabenow, Ranking Member Bozeman, and distinguished members of the committee, thank you for inviting me. I dealt with digital assets as CFTC chair, and I'm here today as Chief Legal Officer of Citadel Securities, one of the world's leading market makers. It's great to be back to support the committee's historic work on digital commodities. As I see it, the Digital Commodity Consumer Protection Act achieves three essential goals. Number one, it addresses a critical gap in the CFTC's jurisdiction. While I was CFTC chair, we brought nearly 20 crypto-related enforcement cases to protect market integrity. But we couldn't write any rules to stop bad behavior before it happened. The CFTC just doesn't have that authority. A number of states have attempted to fill the gap, but the patchwork of differing regulatory regimes is simply ill-suited for a national market. That's unfortunately been demonstrated by the so-called crypto winter. Many of the most vulnerable Americans have suffered massive losses as a result of hacks, bankruptcies, and outright fraud. This bill addresses that glaring regulatory gap. It would grant the CFTC authority to directly regulate digital commodity trading. That would help these markets grow responsibly. They'd have the same kinds of regulatory guardrails that have made our other financial markets the envy of the world. We at Citadel Securities are proud of our 20-year track record of reducing cost, increasing transparency, improving resilience, and broadening access in markets here and around the world. With rules of the road in place for digital commodities, Citadel Securities and other traditional players are more likely to get off the sidelines and get on the field. They'd bring real stability to these markets and replace the bucket shops and boiler rooms. Number two, the bill promotes U.S. leadership in digital asset markets. It would help Americans by enhancing customer protection, focusing specifically on abusive trading practices, a lack of transparency, and conflicts of interest. In addition, all platforms would be subject to financial and system safeguard requirements to improve their resilience. and optional self-certification of new exchange products would encourage responsible American innovation. Number 3, this bill is designed to stand the test of time. Let's start with the obvious. This is a bipartisan bill, and history teaches that laws with broad bipartisan support are more likely to weather political change. Another enduring feature is the bill's appropriate use of principles-based regulation. The bill would allow reasonable yet flexible compliance with core principles. It would also avoid the loopholes that inevitably come when regulations are too detailed to keep up with markets undergoing rapid change. Relatedly, the bill would supplement the CFTC's new authority with a self-regulatory first line of defense. Finally, the bill recognizes the important contributions of regulators other than the CFTC. It also won't tie Congress's hands on the many other issues digital assets raise for the U.S. financial system. All in all, this bill is a huge step forward. At the same time, I think there are at least 3 ways the bill could be fine-tuned. First, the committee should refine the definitions of digital commodity brokers and dealers. This is to avoid sweeping in firms that aren't considered broker-dealers and other well-regulated markets. Second, the bill should have safeguards to protect those who trade digital commodities that have been self-certified or otherwise approved, but then are later reclassified as securities. Third, I recognize that when principles needed fleshing out in the past, the CFTC proactively wrote rules or provided guidance. But I think Congress should make its intent crystal clear that the bill doesn't grant a license for reactive rulemaking by enforcement. As the legislation moves ahead, my colleagues and I at Citadel Securities look forward to discussing these and other aspects of the bill. We also look forward to sharing our expertise in improving investor protection, transparency, and market resilience. Let me end by saying, paradoxically, that 2022 looks a lot like 1922. 100 years ago, this very committee helped to create the Grain Futures Act. Passed in September of 1922, it established the Grain Futures Commission, an early forerunner of the CFTC. The problem then was strikingly similar to the one now. Futures in wheat, corn, and other grains emerged as a truly national financial market. But they were subject to a patchwork of conflicting state laws that failed to protect Americans. The answer then is the answer now, a robust yet flexible regulatory framework that provides clarity and coherence for everyone. I therefore applaud the committee and your staff for advancing this critically important initiative, and thank you so much for having me.
Thank you very much. Ms. Dixon, welcome.
Good morning, Chairwoman Stabenow, Ranking Member Bozeman, and members of the committee. Thank you for inviting me to testify today. I'm so honored to be here, and I look forward to discussing the Digital Commodities Consumer Protection Act. My name is Danelle Dixon, and I am the CEO and Executive Director of the Stellar Development Foundation. Before I speak about the opportunities that are presented by the DCCPA, I'd like to share a bit more about the Stellar Development Foundation and the Stellar Network, and most importantly, the real-world solutions built with this technology. The Stellar Development Foundation, or SDF, was established alongside the Stellar Network in 2014 with the mission of creating equitable access to the global financial system by using the underlying technology presented by Stellar. The Stellar Network is an open, permissionless, decentralized ledger, or a blockchain network, optimized for payments and asset issuance, particularly useful with stablecoins in payments. Today, rather than talking about the things that we read about in the press with respect to trading or speculation, I'd like to highlight a payment service that was built on Stellar, launched in the dead of the crypto winter this summer. In June, MoneyGram, Circle, and a growing number of digital wallets launched a first-of-its-kind global service that enables anyone to convert cash to digital assets without a bank account, without a credit card. This service utilizes the Stellar blockchain and Circle's USDC coin, it's a stable coin, to allow cash funding and payout in different currencies all around the world. The Stellar network provides the digital rails to make payments fast and secure. USDC provides a truly stable digital asset, and while MoneyGram provides a global network of cash-in and cash-out locations. This is true interoperability with the existing financial system. In practical terms, what this means is that an immigrant farm worker in Michigan or Kansas or California or anywhere in the world can send her hard-earned cash to her family and to her home country without experiencing outsized fees or uncertain wait times. She can walk into a local MoneyGram location, typically a supermarket or a pharmacy, with $100 in cash, and in minutes, from start to finish, she can convert that $100 into virtual dollars in USDC. And that's deposited directly into her digital wallet. On the other side of the transaction, her parents could visit their local MoneyGram location and cash out of their own USDC from their digital wallet that she sent to them into their local fiat currency when they need that. This is available right now and is being used right now. This novel service gives neglected, unbanked, underbanked, and cash-reliant populations a pathway to enter the digital economy. So, let me turn now to the legislation. The DCCPA goes a long way towards allowing the kind of regulatory framework that will offer the opportunity for these types of payment services to flourish. And it also, by identifying the CFTC as the spot market regulator. The agency's history of vetting and approving new products demonstrates it is well suited for this type of responsibility. We also applaud the focus on consumer protection and education and its inclusion of the study on energy consumption related to digital commodities. It is also encouraging to see that this bill sets out a process for listing stablecoins and that it is consistent with the PWG report with payment stablecoins not being included as securities. We agree with that, and they're necessary for payments. Rightfully, the DCCPA has defined a digital commodity while recognizing the SEC's jurisdiction. Unfortunately, it fails to address the fundamental question that plagues this industry and has for far too long. When is a digital asset considered a commodity versus a security? The Howey test does not include a clear definition, and it was not an agency-created rule. The industry desperately needs a definition, and the DCCPA is the perfect vehicle for it. Not all digital assets are created equal. As an example of the challenges we face defining digital assets, I referenced the Minnesota and Iowa state fairs in my written testimony, which require tickets in order to experience the full fair experiences, much like you need digital assets to engage with particular networks and services. We need a practical, principles-based framework that focuses on asset functionality. With an appropriate and clear policy and regulatory framework, digital asset and blockchain have great potential to improve access to financial services for millions of people. I believe that the DCCPA is a consequential step towards creating this vision. Thank you again for the opportunity to testify today.
Thank you very much, and very much appreciate all of these suggestions about further ways that we can improve this legislation. So thank you very much. Let me start with Mr. Phillips. One of the important goals, of course, of the legislation is to make sure that we are bringing the trading of digital assets under federal oversight, that we're bringing all of it. And so we know the Securities and Exchange Commission regulates securities, and we want them to do that and want them to do their work, but not all, as we know, of the digital assets are securities. So what are the risks for Congress, or what are the risks for consumers, actually, if Congress does not pass legislation giving the CFTC oversight over digital commodities?
Yes, thank you, Senator. There are so many risks to consumers that we have seen over the past couple of years. Consumers have lost millions, hundreds of millions, billions of dollars through scams, through rug pulls, through hacks, and this bill would enable the CFTC to write appropriate rules to protect consumers against all of those things. For example, the access to exchange data feeds would allow the CFTC to find market manipulation using technology and enforce the Anti-Fraud and Anti-Manipulation Authority. It would require platforms to provide appropriate disclosures. It would allow the CFTC to write enforceable rules around cybersecurity protections for the various platforms. This bill would do so much to protect customers, and I appreciate the fact that all of these provisions are in the bill.
Thank you very much. Ms. Warren, we know that a large number of individuals, as you've indicated, including those in historically underserved communities, are using and trading crypto right now. And our bill, of course, directs the CFTC to study the racial, ethnic, and gender demographics of traders. Senator Booker already spoke to this, and use data to educate, to really inform around outreach and education in rulemaking efforts, actually. Drawing on your experience in the industry and in the nonprofit sector, do you have recommendations for the CFTC about how to do outreach so that we can really reach all of these customers?
I certainly do, Senator, and thank you for the question. I think it's critically important to begin with community need. I'm the co-founder of a project called the Crypto Research and Design Lab, which uses tech ethnography to center these communities that have been historically underserved or even fully excluded by formal financial and technical systems, to articulate what exactly their needs are and how crypto can be a tool of support and provide the kind of financial access that they so desperately need, both for themselves and their families. I think it's critical that this kind of analysis inform everything from disclosure regimes, which need to be in plain language, very clear, so that consumers can make the risk assessments that they themselves are best qualified to make in determining how crypto can best serve them and their families. So I think that engaging in factual analysis is critically important, but beginning with the communities themselves is of paramount importance. In addition, I think we need to have education that begins focusing on not just crypto itself, but on fundamental and baseline digital literacy. And that is something I think needs to be seen and spread throughout our community college system, our post-secondary in general, but even in secondary schools, to ensure that Americans are prepared for the global digital economy, regardless of their background and regardless of the opportunities that they have through being, from wealthier families or from higher income populations.
Thank you very much. Ms. Dixon, colleagues on the House Financial Services Committee are working on a bill to regulate stablecoins, as we know. How would that legislation interact with our bill, giving the CFTC the authority to regulate digital commodities?
Thank you, Senator. It's such a great opportunity to be able to have these bills work together. Having a clear definition of what truly is a stablecoin is so important. We already see in this bill there's a process for listing stablecoins, but it's really important because a lot of what we read about in the early days of the summer focused on things that were labeled stablecoins but were not one-to-one backed with fiat, didn't have audit requirements, didn't have the transparency that we think is important not just for American consumers but also for business who want to leverage these stablecoins, as I mentioned in the MoneyGram example. So creating that very clear definition of what is a stablecoin, holding those assets in a secured financial depository account, making sure that you can't have, that if you do have around the bank, that there's not going to be a problem for the constituents that choose to get their money out. These are all really, really important pieces that we think need to be addressed, and we see not just the bill in the House, but also the proposal that Senator Gillibrand and Lummis put together with respect to stablecoins and defining stablecoins. We'd love to see the idea that we continue to have innovation in this space, but it is regulated innovation around stablecoins.
Well, thank you. Thank you very much, and I have numerous other questions, but I'm going to stop at this point. I'm going to go and vote and leave the committee in the capable hands of Senator Boozman, so don't mess it up. There it is.
So I'm getting a little responsibility. That's great. Senator Gillibrand, would you like to go now, or do you want to? This is our star pitcher, so we'll defer to whatever.
Thank you, Senator.
Would you like to go now and then?
Yes,
vote?
and then I'll go vote. Yeah. So I wanted to, Ms. Warren, I wanted to talk a little bit about DeFi because this is an area where I think we could improve this bill. Right now, for those who are focused on this issue, decentralized finance has enormous opportunity to improve innovation, to work collectively towards creating more financial inclusivity, as many of you have testified about, fewer intermediaries, more opportunities for people of all income levels to engage in the financial system. And while this bill does include decentralized finance in its regulatory framework, I don't know that it is being treated in the way it would need to be treated to actually continue to participate. So I want to talk a little bit more specifically for the benefit of the staff who are working on the next iteration of this bill, what you would suggest laying out in terms of protocols that would apply and map for decentralized finance better than the definitions right now that seem to be overly broad and encompassing too many things that don't really apply.
Thank you, Senator. I agree. I think that the definition proposed as now is, frankly, a bit unworkable in terms of how DeFi actually operates. And I think it's important to note that crypto is not a monolith. And so DeFi, I've been in this space full time now for almost 6 years, and DeFi didn't exist when I entered this space as a concept. It was brand new. So we are really at a point where the cutting edge of innovation is reflected in what we're seeing in this space. And the market hasn't even had time to decide which models make sense, let alone settle into parameters and models that are consistent across different kinds of offerings and services here. I echo your sentiment that this is a critically important edge for financial inclusion in our system. It is going to provide, I believe, over time, increasing advantages to those who simply cannot access other forms or financial services because they have been, again, historically underserved, as the report that is named in the DCCPA so aptly it's so aptly named. I think what's also really important is to ensure that DeFi remains in the United States as a locus of innovation. And the concern that I have, which I've shared with you previously, is that we are going to see offshoring of this innovation space in a way that, as our colleagues on the panel have noted, is going to not embed the principles-based frameworks that are so critical to ensure that Americans receive the adequate protections that they need and deserve, let alone the global citizenry that's going to benefit from this innovation. So as a general matter, we do recommend that this is a space that requires a lot of study, requires a lot of focus on what is happening, what is coming, the trajectory here, but also a bit more time for the space to settle a bit before we try to box it into something that may wind up cutting off avenues that could benefit tremendous groups of people.
And can you just explain it a little more in detail? Because a lot of people don't understand the difference. So if you have a DeFi protocol that never takes custody of assets, does it need to make sure they're not commingled like a bank or something more in traditional finance spaces? Can you explain the difference and why these definitions, unfortunately, may include and therefore exclude DeFi entirely? To just explain the difference for the committee, particularly for Chairman Bozeman and the staff, so they understand why it needs a separate study for this part and to make sure it's not being excluded.
Swept up really in these unworkable definitions. So the way that DeFi works is it is basically an immediate pass-through. It enables a precise peer-to-peer connection between two parties that are engaging in a transaction without a centralized intermediary that's in the middle of that.
And that it's software and it's not an entity. Exactly right. It's not like a group of people managing an organization. It's a software program.
Right. That's exactly right. It is code. It is code that is actually governing this exchange. And that leads to a lot of exciting innovation, but it's also challenging to figure out how do you create a framework around that, because everything that's come before, we've talked a lot about 1922, this is about as opposite from that kind of model as you could get, because there isn't an entity in the middle of this that is directing the flow of funds and pointing things to where they ought to go. It is code that is essentially conducting that same service and providing that same opportunity. So it does behoove us, I think, to think very carefully about the precedent that's being set when we think about a code base that is serving a primary financial service function. How ought we to think about regulation there in a way that protects consumers, but again, retains that innovation edge, and most importantly, ensures that a principles-based framework that is grounded in the U.S. historical approach to financial services is underlying all of that.
Thank you, Ms. Warren. Mr. Phillips, I want to thank you as well for your leadership and the work you've done with this committee and with my staff on writing portions of this legislation in terms of ideas and thoughtfulness. I want to talk a little bit about the issue that people have concerns about energy use and the way this bill will create a study and a protocol to create better disclosure, perhaps, or other recommendations so that the participants can make informed choices. Can you talk a little bit about how you do that, which other regulatory agencies such as FERC we may ask for information from, and explain how we're doing that and how you think ultimately will help long-term?
Absolutely, Senator. Thank you. So this bill would require the CFTC to conduct a study along with other regulators examining the energy impacts of a variety of digital asset commodities. In addition to studying and creating recommendations for Congress and the agency on how to reduce those energy impacts, it would also require the CFTC to list the energy impacts of a variety of different digital asset commodities so that investors can see those disclosures and make investing decisions based on what they see. If there is a token that has an extremely high energy impact compared to something else that is a similar type of token, it's reasonable to believe that investors would move to the lower energy intensive asset, incentivizing the higher energy ones to reduce their energy impacts by moving to a different blockchain or doing something else, reducing the overall impact of energy usage in the crypto market overall. As for other regulators that the CFTC should speak with in doing this, definitely FERC, which does have oversight of the nation's energy markets, the Securities and Exchange Commission, which I expect would also I would want them to examine the energy impacts of those digital asset securities. And in addition, potentially the bank regulators and FSOC who oversee other parts of the digital asset markets.
Thank you. Thank you, Mr. Chairman. I have more questions if you want me to filibuster, but if you have questions, it's your turn.
If you want to ask another question, you're
I have
welcome.
one more. Yep.
As long as they don't get mad at you over on the floor.
Oh, well, they might. One more. Ms. Warren, I have one more. I want to talk a little bit about what happened after the days of Russia's invasion of Ukraine. People were concerned that cryptocurrency would be used by Russian oligarchs to evade sanctions, but that actually wasn't the story that we heard. It ended up being a very important example of how this industry and blockchain technology can be a solution for families, countries, unstable governments that need resources to get them quickly. I thought Ms. Dixon made some excellent points about remittances and how important that is for a world financial market. I care very deeply about access to capital for communities that are disadvantaged and are unbanked or underbanked, and then the banking community doesn't serve it. So I'd like you to augment Ms. Dixon's testimony and talk about some of the really positive stories about how this industry and this technology can transform who has access to capital at urgent times of need. And I think you can use the Ukraine example as one, but whatever ones you want to add to the record.
Well, I think that is the most acute, because I think there is really no question, and I don't mean to sound dramatic about this, there's really no question we'd be in a very different situation in that conflict if the crypto community had not mobilized in response to a specific request from the Ukrainian government all the way up to the president's office asking for crypto donations to bridge and serve as a catalyst while the international community could provide the badly needed aid, the $1 billion of aid that actually has resulted in where we are and the ability of the Ukrainian people to stand up to this brutal invasion. There's no question. Crypto was a bridge. It was a catalyst. It was essential and critical in order to give the international community time to use traditional financial means to provide this kind of capital. And we know, because we can see on what's called a block explorer, where that money went, who it was given to, and also what it was used for. So we know, based on all the accounts that come from the Ukrainian government, this was medical supplies. It was, in some cases, arms. It was just things that were critically, vitally important at that crucial time. In addition, we've seen crypto be a critical tool for activists, those who are working in some cases with the U.S. government against rogue states to actually provide money, whether it's money to get them securely out of a country at times when their lives are in crisis because of political happenings around them. We've seen this all over the place. We've also seen women in times of trouble, and Afghanistan is probably a really great example of this, maybe the best, where in a patriarchal society where when the Taliban came in, they were looking to basically seize and appropriate funds, and the community was using crypto, particularly women were using crypto in a way to shield assets from that seizure. which is critical, and again, provided the ability for people in that country to resist the authoritarian regime that's being pushed upon them. So these are examples that I think are located in other countries, but they are so critical, and they underlie, in my opinion, the nature of crypto and why it is so important, to your point, in times of crisis. And the reality is that here in the United States, we certainly have communities in crisis as well. And so these may not be the examples that are as popular or as noted, because they're quieter examples, and they maybe aren't as dramatic in terms of the opposition that's being faced. Nevertheless, there are communities here that also have been unable to get access to basic financial services that are turning to crypto, and the numbers speak for themselves, and we quoted them already. So whether or not you're in an acute situation or a crisis, I do find that preserving the opportunities that this particular innovation represents is of critical importance. And again, grounding that in the principles-based frameworks that underlie the American financial system are also of critical importance.
I just want to thank the entire panel. I appreciate your testimony and the information you're giving to this panel about the urgency and the importance and the benefits of really creating these regulatory frameworks now. Thank you so much.
Thank you. Mr. Phillips, we appreciate the good work that you and your organization are doing in trying to educate the public as to what we're trying to accomplish here. This topic is something that is anything but easy to understand. One of the things that we're hearing is, from some of the other consumer advocacy groups, is that somehow this would erode the SEC's authority to police the crypto market, and the CFTC is ill-prepared to ensure retail consumers are protected. Would you agree our bill specifically defers to the SEC when it comes to those digital assets deemed securities, and only looks to provide the CFTC regulatory authority over digital commodities? The other thing that we're hearing along with that is that somehow, they would be underfunded, they wouldn't be able to do this. You might reiterate the importance of user fees, and that would be fine. So again, like I said, those are two of the major things that we're hearing. If you would address that, it would be helpful.
Sure. Thank you, Senator. This bill, as I read it, specifically defers authority over crypto securities to the Securities and Exchange Commission and reserves for the CFTC authority over those assets that are crypto commodities. My understanding is that since introduction, there have been one or two places where it's been identified that the SEC's authority may be impinged, and in my written testimony, I make recommendations to address that. I want the SEC to retain authority over securities and CFTC authority over commodities. I also think that the CFTC, with this bill, would have the regulatory capacity and expertise to be able to address these markets. The CFTC is an excellent regulator. The commissioners and the chairman are excellent regulators, and I think they have the best interest of customers, crypto customers in mind. As for the underfunding, I think all of our regulators need additional resources. I encourage Congress to, if it enacts this bill, to also increase the CFTC's budget. I do think that the user fees that the CFTC would be able to collect would perhaps make it easier for Congress to increase the budget to a point where the CFTC can appropriately regulate this industry. On the first panel, we heard Chairman Benham mention that he expects that the CFTC would need an increase of $112 million over 3 years. That sounds like an excellent bang for the buck to get these assets appropriately regulated.
Very good. Thank you. Ms. Warren, I was going to ask you a question about the DeFi, but I think, I appreciate the discussion that you and Senator Gillibrand, had, and certainly that's something that we're very concerned with getting that right, so we appreciate that. Ms. Parker, your testimony discusses the current regulatory framework under which cryptocurrency exchange operates. Please speak about the various state and federal regulators of Coinbase, where there might be gaps, particularly relating to consumer protection measures, and why it makes sense to provide the CFTC with exclusive mandatory federal regulation of digital commodities as set forth in the bill?
Thanks, Senator. That's a great question. I will say there are many state and federal regulators that regulate Coinbase. One of our big challenges is, particularly with respect to consumer protection, is that it generally falls to the state banking regulators under the money transmitter licenses to carry that mandate. And so it's not so much that we are unregulated in this space or there are gaps in the regulation, it's that it's not consistent across states. And in particular, I would point to our disclosure requirements. Each state has its own set of disclosure requirements for consumers. Not all are tailored to digital assets. And so this bill solves a critical gap in the sense that it would bring in a unitary federal regulator with that would provide a consistent set of consumer protection requirements that would apply equally to all consumers and would do so in a way that's tailored to the nature of the market and the assets. And you know, the CFTC has been active in this space for a number of years, but this regulation fills the gap with respect to commodity spot transactions in the spot market. So we would certainly welcome you know, that role for the CFTC in this space.
Good, thank you. Dr. Tarbert, your testimony raises an important point, how this committee may provide further certainty to market participants who comply with the bill's registration requirements for listing a digital commodity, but somehow subsequently run into an SE threat to reclassify what appears to be a digital commodity as a security. How can we address that problem?
Thank you so much, Senator, and for your leadership on this important issue. I think that is really the key here. You know, many established market participants and other markets like Citadel Securities are looking for that clarity and coherence. And as you say, one of the issues could be if something is reclassified after the fact, we would want the kind of certainty that comes through a safe harbor or something during the time in which we're trading those instruments, to be able later on to not face, you know, civil litigation, other kinds of enforcement actions for a change by the regulator itself.
Very good. Ms. Dixon, again, another thing, and this has been discussed already, but I think it is important because it does come up. It's my understanding the energy consumption required for proof of work consensus mechanism transaction validations can be significant, which is why I'm glad our legislation looks to study the issue. What is your view on measuring energy usage related to various consensus mechanisms in the crypto space?
Thank you so much for the question, Senator Boozman, and thank you for your leadership and that of your staff on this. The environmental and what the bill presupposes about the study that needs to be done with respect to the environmental impact of all the different consensus mechanisms is so important. It's something that we do in lots of other industries to be able to figure out the benefits and the harm that each of the industries or each of the different challenges bring to the United States. All consensus mechanisms are not alike, but importantly, what we can do and what we're hopeful that this study does is create a framework for how to measure the carbon output and figure out what we need to do as an industry to even further improve it. We just saw last night, I think it was at 2:34 a.m. In Eastern Time, where Ethereum moved from proof of work to proof of stake. That was already a momentous shift from that in terms of demonstrating the increased sustainability for that network by moving to proof of stake. So I think, again, not all consensus mechanisms are created equally, but if we think about a framework, which we've done, by the way, we've engaged PwC to create that kind of framework to consider how you should, and we've done it with respect to the Stellar Network, what pieces of the Stellar Network and what pieces of the transaction should be viewed when you're looking at the sustainability impact as a whole. We welcome that kind of framework. We think that the industry needs that to be able to create consistency and to understand really truly the value and also the potential harm and what we can do to improve on it.
Good. Thank you very much. Madam Chair.
Well, thank you very much, Senator Bozeman. Thanks so much to all of you, and we appreciate your testimony. Look forward to continuing to work with you, and also appreciate so much Chairman Benham and his leadership at the CFTC, which is going to be so critical moving forward. We saw last year a lot of volatility in the marketplace, and we have a bill that's going to address that to make digital commodities safer for Americans to use and to trade, and again, investing in and supporting the innovation and the opportunities as well. So I think this is a really important opportunity for us to move forward, and I'm hoping our colleagues will join us on this bipartisan bill so we can get the CFTC to work. And again, thank you. The record will remain open for 5 business days for members to submit additional questions or statements. And without further comment, the meeting is adjourned. Thank you.